All right, and these have been received from CNN, which I've approved. The Atlanta Journal-Constitution photostat, which I've approved. The Associated Press request, which I've approved. Ms. Lydia Tisdale's request, which I've approved. I believe that we've seen her previously. CBS 46 request, which I've approved. WXIA TV's request, which I've approved. Is there anyone else? All right. Next, there is a request for stay of the proceedings by special appearance. I take it that that's been resolved as between the parties because it's effectively been stayed. True.
We agree, Your Honor. We agree, Your Honor.
All right. Likewise, with the emergency motion for protective order, an expedite ruling, that's been resolved for the purposes of today. Is that true?
The protective order for depositions, that's right, that's been resolved. That's correct, Your Honor.
Next, we have the motions to quash. And also the motions to withdraw. We have, let's start with the motions to withdraw. I believe that we have Stephen E. Rosenberg, who's seeking to withdraw. And he's seeking to withdraw as attorney of record for respondent Fulton County and Fulton County Board of Registration and Elections.
Your Honor, if I may, I'm Steve Rosenberg. It's really just to withdraw. Well, I think I also filed almost at the same time a motion for an entry of appearance on behalf of Fulton County. So I'm here to represent Fulton County. We had previously filed an entry of appearance for the Board of Registration and Elections. That's really what I want to withdraw my representation from.
All right, and that's because you have substitute counsel.
Correct.
Okay. Just cleaning up the record.
No, sure. Thank you.
Any objection?
None.
Hearing none.
None.
None. Then Mr. Rosenberg will be here on behalf of the county.
That's correct, Your Honor.
Only. We also have a motion to withdraw of attorneys by consent that was filed by Mr. Harding, essentially informing the court that Mr. Chile does not represent Mr. Favorito, Mr. Skupin, Mr. Terrace, Mr. Dremy, Stacy Doran, Christopher Peck, or Brandy Taylor.
Yes, sir. I think we had told you that at a prior hearing. There's just never been an order entered. I just thought it was a matter of housekeeping more than anything else.
Well, that's why we're addressing it now.
Yes.
And I take it there's no objection.
There's no objection, Your Honor.
All right, and,
And I have a proposed order.
all right, we'll take a look at that. You can,
And Your Honor, just for the record, Bob Cheeley, along with Charles Bundren, we represent two petitioners, Caroline Jeffers and Robin Sotier.
all right, thank you. And we also have others with us today. We might as well go ahead and get everyone to introduce themselves over at this end of the table. If you would please stand if you're an attorney who is representing a party and indicate your name and who you represent.
Good morning, Your Honor. Kay Burwell on behalf of the Clerk of Superior Court.
Good morning, Kay. Ms. Burwell.
Good morning, Your Honor. Debbie Bankscorn on behalf of the Superior Court.
Good morning.
Good morning, Your Honor, Steve Rosenberg on behalf of Fulton County.
Welcome.
We're Your Honor, Don Samuel, Amanda Clark Palmer on behalf of the Board of Registration and Elections.
Welcome. Good morning. Nice to see you.
Preston Halliburton on council, Carolyn Jeffers, Robin Sotier.
All right. Thank you. Welcome.
Please the court, Charles Bundren on behalf of petitioners Jeffers and Sotier.
All right. Thank you. Welcome. And Mr. Chair.
Yes.
Okay. Looks like we have everybody here that we need. We also have as I previously indicated, motions to quash. We had a non-party MVA Scientific Consultants motion to quash subpoena for production of documents, information, and objects. Is there anyone here? Is Michael Elkin here who represents this non-party? Is there any issue that either party wishes, any party wishes to address with respect to this non-party motion to quash?
Your Honor, that particular motion to quash dealt with an expert that we were considering using, but we have since decided not to use him. And that was filed on behalf of his employer, so we don't have an issue with it, and so it's moved.
All right. No one else wishes to be heard in connection with that one?
No, sir.
All right. That motion is rendered moot. Okay, we also have a motion to quash subpoena served on Richard Barron, Director of Elections, Fulton County.
Yes, Judge. And we are asking the court to quash that subpoena, which was served for today's hearing on Mr. Barron. I don't know if the court had time to read our motion because it was filed late last week. I'm happy to summarize it, or if the court's read it, then we'll rely on what we put in our motion.
I have read it, but I think that it's important to summarize it nonetheless.
Sure. Our argument is really twofold. The main point of the argument is that his testimony is not necessary for the proceedings today. Today, the court's hearing argument on motions to dismiss that were filed. Motions to dismiss by their nature are determined based on what's in the pleadings, not on any evidence that's developed outside the four corners of the document. In this case, the complaint that was filed by the petitioners. So we don't understand how there's any legal basis for the court to hear witness testimony today on a motion to dismiss. If the petitioners think that they need that one of the respondents has made a factual argument, well, then they can argue to the court that's not the appropriate way to decide a motion to dismiss. What the court can do is then allow discovery on that issue. And it essentially, I think the case law says it essentially turns it into a motion for summary judgment when the court is considering evidence outside the document itself. Second, it will work an extreme hardship on Mr. Barron to appear at the proceedings today. He had prearranged, prepaid for significant travel plans out of the state. And
San Diego and Hawaii.
correct, that had been made long in advance before the court set this hearing, and for sure before he ever got a subpoena from the petitioners. So for those two reasons, we're asking the court to grant that motion today.
Okay, and let me see, do we have a response?
Your Honor, Bob Cheatley, I believe this particular subpoena requiring Mr. Barron to attend today also will be rendered moot based upon the court's consideration of the motion to dismiss that was filed on behalf of the Board of Registration and Elections. We believe that under the amendment to the Georgia Constitution waiving sovereign immunity, that the proper party in this case is not the Board of Registration and Elections, but instead would be Fulton County itself, and we are prepared, subject to the court hearing argument on the motion to dismiss filed by Fulton County first, subject to the court's determination on that motion, we would voluntarily agree to dismiss the Board of Registration and Elections and the clerk of court. So
Okay.
we believe that the subpoena requiring Mr. Barron to attend today, in that situation will be rendered moot once the court hears argument, our argument in opposition to Fulton County's motion to dismiss.
All right, well, thank you. And let me see, I believe that I was remiss in not attending to this side of the courtroom issue, and I apologize for that. We also have Mr. Harding, who's here. Mr. Harding, can you please indicate who you represent? And Mr. Coombs.
Yes, sir.
We represent Mr. Favorito, Mr. Shuffin, Mr. Terrace, Mr. Drain, Ms. Doran, Mr. Peck, and Ms. Taylor, Your Honor.
And do the two of you wish to be heard in connection with this motion to quash?
No, sir.
And do you disagree with anything that we have done so far in terms of handling the housekeeping matters?
No, sir.
All right, thank you both.
Thank you.
All right, I'm going to go ahead and grant the motion to quash,
Thank you.
and it appears to be with the consent, but it seems to come with some sort of stipulations or conditions, but I'm going to find that it's proper to grant it even without those.
Thank you.
Let's see. We also have a motion. We have petitioners. Let's see. This was as to Richard Barron. We also have responded to Fulton County's motion to quash subpoena served on Robert L. Pitts, Fulton County Board of Commissioners Chairman.
Correct, Your Honor, yes. Yeah, I assume the same reasoning applies with respect to that subpoena. I think they wanted to bring Commissioner Pitts here to sort of rebut our argument that Fulton County doesn't run elections, which is really, it's an improper party argument, which is an analysis under the law, purely under the law. But if they believe they have now the correct party is Fulton County, that issue may be moot as well.
I agree. We don't need, since we served as being on Mr. Pitts, we've since found documents that link Fulton County to elections and the running of elections, which we filed as part of our supplemental brief in opposition to Fulton County motion to dismiss. So therefore, we don't need Mr. Pitts, and we'll voluntarily withdraw that statement.
All right, it's withdrawn.
Your Honor, Mr. Pitts is here. May he excuse?
Yes.
No objection, Your Honor.
All right, thank you. Mr. Pitts, thank you for being here. You're excused. I believe those are the only motions to quash that need to be heard by the court. Is that correct?
Yes, sir, that's mine.
All right. Does anybody disagree?
No.
All right.
No, Your Honor.
any personal identifying information. So that's something I'm gonna need some feedback on. Now, I want to shift now to the motions to dismiss, allowed to inspect them, which I suspect will be lengthy in their presentation. But before I do that, I want to be sure that all of the last minute filings have been received by all of the parties. And I have received some copies that I'm not sure have been filed because they were just received here this morning. I want to make sure that we don't have any confusion in that regard. So let me just touch base with everybody about some of the filings that I see that don't bear file stamps. And you know, there's sometimes a little bit of a delay between the time that they are submitted to the clerk and e-filed. And it's sort of a natural process, but nevertheless, we have to make sure that everybody's reading from the same sheet of music, so to speak. So let me start with this pleading, which is petitioners Jeffords and Sotier's opposition to respondent Fulton County untimely motion to dismiss. Has everybody received that? Is there anyone who has not received it? We have petitioner's second amended petition for declaratory and adjunctive relief. Is there anyone who has not received that document? If so, please raise your hand. We have petitioner's motion to change venue for audit. If you have not received that document, please let me know, and I'll make a copy for you. There's also a proposed order granting petitioner Caroline Jeffords and Robin Sutor's motion for review, inspect, and analysis of ballots and other documents. Has everybody received a copy of that? If not, please let me know.
I'm sorry, could you read the title one more time?
Yes, it's proposed order granting petitioners Caroline Jeffords and Robin Sotier's motion, review, inspect and analysis of ballots and other documents.
Yes, we got that.
All right. Next, we have petitioner Jeffords and Sotier's motion to substitute. Has everybody received that? Has anyone not received it? All right, no hands. Next, we have petitioners Jeffords and Sotier's supplemental brief in opposition to respondent Fulton County untimely motion to dismiss. Has everyone received that?
Yes, sir.
All right. Okay, so we have a complete set of documents in everybody's hands. That's good.
I have filed some additional documents from, filed our own, my petitioner's second amendment to the petition. Filed it Friday morning. I believe I circulated it. Then I filed a response to the motions to dismiss Saturday morning. And I believe I circulated a copy of that to everyone.
Well, Your Honor, I don't know that I was on that circulation. Someone read it to me this morning on the drive-in, but I you know, within reason, I could probably respond to it. If the court has any further questions that I'm not able to deal with, you know, I'd ask you to just allow me some time to file something responsive.
Do you have copies there?
I have my copy, but I'm going to do it if you like.
I think I'm okay. I'm okay. No, I've got an extra copy, Judge.
Okay. Let me make sure I have it. Let me see your copy, please.
I think it's only one.
Just come right around here. Thank you. No, I have not seen these. Okay, Mr. Philip, what would you down here make copies for me, and then return these to him? Did I hear you correctly, Mr. Chile, when you said that if we heard Fulton County's motion to dismiss first, then you might be in a position to dismiss the clerk and dismiss the BRE?
Yes, Your Honor. It's our position that under once the court hears argument on the amendment to the Constitution of Georgia that was approved by the voters in November of 2020 and took effect January 1st of this year, that Fulton County's motion to dismiss should be denied. And if that is denied, then we believe that we'll voluntarily dismiss the Board of Registration and Elections and the clerk of court.
Well,
Take them in that order.
I think what I prefer to do is to hear argument from all of the parties that are that have filed motions to dismiss. Consider each of their arguments and then make a ruling on all of the motions. And I understand that there's going to be some duplication of argument, but they're not all the same.
We've endeavored not to duplicate argument to the extent possible, but
Okay, and so what we'll do is, if it's is we'll start perhaps with this side of the table and go forward to that side of the table. We'll start with the BRE, and then go to Fulton County, then go to the clerks. I think that it might make sense to give you a chance to argue in that order and then have a response from you in that order, Mr. Chile, and then have a response perhaps from Mr. Harding in that order as well. I think that appears to be an efficient, economical way to do it. Anyone have any objection with that procedure?
No, sir.
No, Your Honor.
All right, thank you. And who's going to be arguing on behalf of the BRE?
Your Honor, Don Samuel, on behalf of the hearing. May I remove my mask while I'm arguing, or do you prefer not?
Have you been vaccinated?
I have, Your Honor.
You may.
Thank you. Your Honor, I think there's nothing that's very controversial or ambiguous or debatable about our sovereign immunity motion. It sounds like both sets of petitioners essentially agree with our position. The constitutional amendment is very clear that sovereign immunity, the waiver of sovereign immunity upon which they're relying to prove the case against the county, does not permit, and it's absolutely clear, you may not sue other entities, individuals, subsidiary bodies, public bodies, such as the BRE. The VRE is simply, immune from lawsuit under the sovereign immunity established by Lathrop versus Deal and all the cases that came before. You can't bring declaratory judgment actions, you can't bring injunctions, you can't bring any kind of lawsuit at all against the VRE. There are exceptions which may come to play at some point in this case. It is conceivable, for example, that the petitioners will bring a Open Records Act claim against the VRE. And it is our position that in all likelihood, sovereign immunity doesn't apply to an Open Records Act case, a mandamus case, or the other types of legislative acts which clearly envision lawsuits against a public entity. My understanding of the history of this litigation, and I've read absolutely everything, is that counts 8 through 10 have already been resolved with the Open Records Act claims. 10 was the first amended complaint. 7 was the injunction that kind of doesn't really, more or less, has been granted at this point. So, it is conceivable we'll be back in the case, and that's why, dismissing us, I'm not sure that Ms. Clark Palmer and I are going to go and walk out the door, because I think that the BRE is going to remain involved, not only for that reason, but also for reasons that came to light Friday night with their most recent filing to substitute. And I'll address that as well, if I may.
You may.
This morning. But as a named respondent, it's not permissible. And it sounds like, Mr. Cheeley, Mr. Harding essentially agree with that. And if the county is correct, and I'm not going to argue one way or on behalf of the county, that they have nothing to do with elections and therefore they can't be sued, that doesn't change the constitutional amendment. The notion that, the county can't be sued, therefore we have to sue the BRE is not a response to the constitutional amendment. It's not a response to sovereign immunity. I was counsel of record in Lathrop versus Deal. That's exactly the argument we made in Lathrop. If you don't let us sue, there'll be no relief. And the Supreme Court said in a very eloquent way, tough, right? I mean, that's just the way sovereign immunity works. Complain to the legislature, get a constitutional amendment if you want to. So that's, of course, what the people of Georgia did. So I think there's no reason to waste much more breath on the issue of sovereign immunity. I do want to raise the declaratory judgment issues, which deal with counts 1 through 6. And we have briefed that fairly extensively in our motion to dismiss we filed last week. It is our contention that a declaratory judgment action is entirely inappropriate in this case. There is, you look like you're about to say something.
Is there some future uncertainty I'm also vaccinated.
That's what you look like.
Is there some future uncertainty in this case that's being alleged by the petitioners in the 4 corners of the complaint and amended complaints that would make the declaratory judgment an appropriate vehicle?
Up until Friday night, I'd say that's not even a close question. Up until Friday night, there was nothing alleged about the future. The essence of a declaratory judgment action is that you and I are in the midst of a dispute about the current state of affairs, right? Not about what happened last November, not about what happened last January, but today we are engaged in a dispute about our current relationship, whether it's contractual, whether it's typically an insurance company refuses to provide coverage, or whether it's statutory, the constitutionality of a statute. And a doctor says, I want to perform this operation, but there's a statute that says I can't. So there's a current controversy. And when I say that, I'm not saying that we are controversial or antagonistic about some past event. Okay? Whether there was anything that happened inappropriately in November is not the subject of a declaratory judgment action, because there's no current controversy. There's no controversy today about our relationship, even if something inappropriate happened 3 months ago. So that's the essence of a declaratory judgment action. Part 1 is the current controversy. Part 2 is that it needs to be resolved in order to resolve our current controversy. That's why insurance companies sue people for declaratory judgment action, so they don't have to provide coverage in the future. That's why plaintiffs sue the Secretary of State or the governor or the Attorney General, because there's a statute that prohibits future conduct. Uncertainty is not a basis. The uncertainty about what happened 3 months ago is not a basis. And uncertainty about whether I'm going to have equal protection rights is not a basis, or due process. Listen, I don't mean this facetiously. We'll stipulate. We will stipulate. We will not violate your due process rights in the future. We will not violate your equal protection rights in the future. We will not do anything criminal in the future. The court knows you can't grant an injunction that says you will not commit a crime. There's already a law that says you shall not commit a crime. So this, up until Friday, there was not a word in the complaint about the future. Not one word. It was all looking back about what happened in November. And in fact, if you look at the prayer for relief today, even after Friday night, and I'll explain to you why I keep referencing Friday night, even if you look at the prayer for relief, it still says, declare that what happened in November was illegal. Declare that what happened in November violated the petitioner's due process rights. Declare that what happened in November violated the petitioner's equal protection rights. With all due respect, you can't do that. Not in a declaratory judgment action. You can do an election contest. You can do, conceivably there'd be a 1983 action in federal court. It could be all kinds of things, but not a declaratory judgment action. So what happened Friday night? What happened Friday night was that the petitioners in the jury box, the group of 7, purported to amend the complaint and said they were uncertain about their future rights. Well, that's not a declaratory judgment, because the declaratory judgment has to resolve the nature of our relationship. Okay, whether it's the BRE and frankly the county or the members of the BRE who now they seek to bring in, there's nothing about our relationship that needs to be resolved. What they're really saying to you in absolutely plain English, and I seriously doubt they will contest it, is you're not allowed to violate our rights in the future. That's what they're saying. Their amended complaint says you shall not stuff the ballot box in the future. You shall not fail to count our votes in the future. That's not a declaratory judgment action. A declaratory judgment action under the official code is to resolve today's controversy so that in the future we know what our relationship is. There's no relationship between the group of 7 petitioners. And if you're going to grant this motion to add parties, the 7 members, the 5 members of the BRE, there's nothing about their relationship that needs to be clarified. There's no legal decision you need to make that says the 5 members' relationship to the group of 7 is as follows. And their protestation today that they are uncertain about their rights in the future, the Constitution applies to them. We'll stipulate. They have a right to due process. They have a right to equal protection. They have a right to every right that's conferred upon them by the United States and Georgia constitutions. There's nothing for you to resolve in this. And they still haven't amended the prayer for relief. Everything in the prayer for relief says, we want a declaration about what happened in November. So we believe that the counts 1 through 6 need to be dismissed as to the BRE, presumably the county as well, because there is no existing controversy, and there's certainly no controversy that needs to be resolved in the future that resolves the existing controversy.
Is there a difference between OCGA 9-4-1A and B? And what is that difference? And is it material?
I don't have the code in front of me, I'm sorry.
Here, I'm happy to provide it. Sure, if you don't mind using a book.
How do you plug it in?
What was that code section again?
941A.
941.
Just go and share with me. Your Honor, I'm looking at B. A is what we generally refer to as declaratory judgment, but they both seem to refer, and I'm reading quickly. They both deal with an existing controversy, not about the past, not about what happened in November. If anybody on our side of it, not including the jury, but our side meeting here, were to say it's perfectly okay to stuff a ballot box, then you would have a declaratory judgment action that's viable. If anybody on our side said, oh, a few votes here and there, who cares? You know, we just don't bother counting them after 10 o'clock at night. If anybody were to say, we think that's okay, you would have a viable declaratory judgment action, because that needs to be resolved. But to say that it happened 4 months ago, 5 months ago, 6 months ago, 10 years ago, under their theory, there's no statute of limitations under the declaratory judgment action, because it's always a current controversy. That's why there is no statute of limitations for a declaratory judgment. It's because of the currentness, it's because it's contemporaneous is the problem. So it is our contention that declaratory judgment action counts 1 through 6, as pled, need to be dismissed, and the amended complaint needs to be dismissed, the second amended complaint. If I can just make 1 or 2 more quick points.
Take your time.
I don't want to take up too much of your time. And this is clearly housekeeping. On Friday and Saturday, we got 2 second amended complaints. They are different, which is okay because there's 2 different groups, but I'm not quite sure what is the complaint we're responding to anymore. We got 2 counts 109, 2 paragraphs 109, 2 paragraphs 110, have nothing to do with each other anymore. At some point, we need to clean this up and have either a second or a third, let the 2 of them decide who's the second, who gets the odd number amended, who gets the even number. Because I can't even refer back to you now which paragraphs we're complaining about.
You can refer to the pleading itself and how they've styled it.
Well, they're both second amended petitions, but it's the group of 7 that has amended it to deal with the declaratory judgment action. And they have some paragraphs. In my notes, I had it paragraphs 83, 84, kind of in that range. And what they say is that what I've been saying, which is that they claim they're uncertain about their fundamental rights to have their votes counted. Well, that's not true, in all honesty. They really are uncertain about their rights. We can tell them their rights. You can tell them their rights in court. They have rights. They have due process rights, equal protection rights. They have every right conferred upon American citizens to vote. That is not a question in this case. Nobody's ever questioned the Constitution protects the right to vote. What they're contesting is that their rights were violated. And for that, you need to make a factual inquiry into what happened last November. And that is not what is the proper subject of a declaratory judgment action. And finally, I want to raise one more point, which deals with what is really the essence of what this litigation is, which is the right of the petitioners or their experts or their witnesses to look at the ballots. And to that extent, I'm not sure everybody on this side of the table, this side of the courtroom, is in 100% accord. The BRE, my clients, recognize that the legislature has conferred upon the petitioners the right to look at the ballots, the scanned ballots. And I've read your orders, which seem to suggest that they can get a better scan, a scan that provides higher resolution. Frankly, I haven't lost any sleep about that, I'll be honest with you. The county may disagree with me, and so that's why we're 2 different parties. I recognize that under Section 500, the court has the authority, under some standard that nobody seems to agree about, to unseal ballots and to let them look at them. I haven't lost any sleep about that either, to be honest with you. I'm not sure it's correct. I'm not sure it's a viable thing to do in this situation. But the BRE has not, my clients have not taken a position on that as of now. The county has. I think it's unbelievably important to do what we were going to do on May 28th, And the notion that we filed all these motions to stop that is absolutely wrong. And I'm not blaming the court or the petitioners as much as the social media and the world out there that we can't really ignore. Everybody thinks we filed motions, to stop the audit or to stop the count. That's not what we did. We filed motions because we were never served. We filed motions because of the sovereign immunity clause, and we filed motions because of the impropriety of a declaratory judgment action. But we have never said to you, and we've never said to the court, and we've never said to the petitioners, you have no right to look at these ballots. What we were going to do on May 28th, I think is important and needs to be done, which is to set up a protocol which protects the ballots, protects everybody's rights, and doesn't turn into a circus like occurs elsewhere.
Mhm.
And I know that's why the court wanted to meet on May 28th, so we agree with that. And I know I said one more point, but when a lawyer says that, he never means it. There's a motion that was filed on Friday night by the group of two, which I think the group of seven kind of agreed to, which is to substitute parties or to add parties. I think Mr. Harding's group called it a misjoinder. Well, they weren't in the case at all as of Friday night, so the people that are being added back in are not, it's not a misjoin, it's just to add parties. And Mr. Cheeley's motion says to substitute, but it's not really to substitute, because even though the caption says substitute, the body of it says add. Those are actually two different sections of the code. We oppose that. But I'm a little, I oppose it on behalf of the BRE, which may not be in this case anymore. So it's a little dicey. We also, I believe that
Seems like the folks who would be in opposition to it are potentially the ones that are added.
Yes, okay, I'm sorry, I missed the last word. Of course, that's the problem. And I originally had actually written a brief that said to you, you have to give them a right to be heard about whether they should be added. But then I realized they don't really have a voice until after they're added.
They would file a motion to dismiss.
Exactly. So the question is, do you want to, go home for a week and come back here next week, or should we address some of those issues now? And I'm going to do it, I promise, incredibly briefly. I believe the same arguments we're making about declaratory judgment actions using the BRE apply to the added parties. And the added parties, of course, are the 5 current members of the BRE, 4 of whom have already been served in the original case, because we're kind of like a tennis game. We're going back and forth here. We can't quite.
Well, the question I have, is it just to add them? If it looks like the for instance, the declaratory judgment statute doesn't provide these folks with a remedy. And so I'm going to give you a little bit of latitude there.
Yeah, well, I think that's exactly the problem. I think that, well, a couple of things, just so I don't forget. First of all, Alex Wan is one of the new added parties. He wasn't in the case before, so he's never been served. He wasn't even on the board last November, right? I mean, he came on in February, March, something like that is when he was, I mean, he's the chairman of the board. He wasn't even there back in November, for what it's worth. Everything I said about declaratory judgment action, the impropriety of a declaratory judgment action against the BRE applies doubly on steroids when you talk about individuals in their individual capacity, right? I'm not going to name the 4 people here, but the 4 members other than Alex Wan who were there in November, there's no controversy between the petitioners and these people individually. These people I'm referring to, the 7 petitioners or the 2 petitioners. They have no controversy with these people individually. The prayer for relief, again, doesn't say that the rights with respect to again, I'm not going to go through their names, but the 4 members of the board who are public servants doing everything they can to run an election. Nobody contends that they were stuffing ballot boxes. Nobody contends that they individually, in their individual capacity, were intentionally not counting votes. These are unpaid public servants who serve on this board, who are trying to keep up with the COVID last year and keep up with the chaos, and the Secretary of State says we're going to have absentee ballots for everybody, and suddenly they're just swamped They did everything they could to keep this election moving forward. The members, these individual members, who now are gonna be sued in their individual capacity? To do what? To declare that the petitioners have constitutional rights? Of course they have constitutional rights. These individuals would not even contest that. Of course, these people have individual constitutional rights to due process and to equal protection. That's not what a declaratory judgment action could possibly be. I file a motion for declaratory judgment. I want you to declare that I have due process rights next year. It makes no sense. So we would ask you not to add parties. I would point out that there's no citations in their brief to substitute. You have to approve it. They did file it. It is a motion. So they're asking you, and I would just point out a couple of cases that talk about your need, court's need, you respect, you always have to say that, to exercise discretion in deciding whether to add individual members of the board here. And I've got a few cases, I can cite these to corporate Clover Realty versus JL Todd, 237 Georgia, 821, 1976 Supreme Court case. These are absolutely.
If there's no viable claim as to them, then the question is why exercise your discretion to permit them to be added, only to have a motion to dismiss be filed that ultimately would be granted.
You're much more concise than I am.
If I'm,
exactly.
That's your position.
That's our position. There's nothing to do. There's no declaratory. There's no Open Records Act counts left. There may be some in the future. That's why this is. I don't know how many times we're going to come back. They've filed so many Open Records Act requests just in the way, and they have a right to. Don't get me wrong. But my guess is
those really aren't the issues right now. These are the due process claim and the equal protection claim.
That's right.
That's where we are.
That's exactly right. I think that sums up the BRE's position, and to some extent, the position of the individual imminently to be added parties, individuals. Thank you, Your Honor.
Thank you. Okay, Mr. Rosenberg.
Okay, I thought you were gonna offer them an opportunity to respond and then go here.
No.
Go here, that's fine. Thank you, Your Honor. And I similarly remove my mask. I have.
Are you vaccinated? All right.
So I guess the large issue, right, is they've sued Fulton County. Fulton County is immune from suit, right? We have sovereign immunity. That's always been the case. It's a life-free deal, sustainable coast, for deck actions, for everything else. And then their response is, well, but there was a waiver, right? But no one wants to read the waiver, although they do admit it in both of their most recent filings that the effective date of that waiver is January 1st of this year.
What about waiver by conduct?
Waiver
The
by
fact that this action was filed when? December of 2020?
Sure.
And the county has participated in this litigation since that time.
Sure. Your Honor,
So I'm curious, do you have the ability to sort of turn it on and turn it off whenever you want?
with respect to sovereign immunity, we absolutely do, right? You can even raise that for the first time on appeal. You can raise that at any time.
It's like a motion in arrest of judgment.
Yeah,
It's like a general demur.
It's one of the sort of special circumstances that you can raise it at any time. But more importantly, Your Honor, I mean, and I appreciate their position, but Fulton County's been in the case, but we've never been in the case. We were never named a party. We weren't served until June, right? This month, this year. Our answer isn't even due. Now, have lawyers from the county attorney's office appeared on behalf of individual members of the BRE back in, December or whenever this was filed, November? Sure, but the county's never made an appearance.
I think a careful reading of the transcript would suggest otherwise. Nevertheless, let's assume that Fulton County has made an appearance.
Sure.
Are they still entitled to sovereign immunity?
Yes, absolutely, and I'll explain why. So up until January 1st, the county had a blanket immunity, right? That was the whole purpose behind the passage of the amendment, constitutional amendment, because we were immune from all claims immune from temporary restraining orders, declaratory relief, the cases cited in our briefs. And then the people spoke and the legislature passed House Resolution 1023. 1023 says that sovereign immunity is hereby waived for actions of the Superior Court seeking declaratory relief from acts of the state and state agencies, which the county is. So if you look concerned, I want to address a concern.
I'm just not aware of any case that says that you can waive sovereign immunity by participating in the litigation.
Oh, no, there isn't any.
That's what I was
I'm
wondering.
sorry, I thought I had responded to that. I apologize. No, that's why I said you could raise it on appeal. We could
No
go through
case.
and never
Never.
raise sovereign immunity ever, and engage in depositions and file summary judgment motions and lose at trial and take it up to the Court of Appeals and then say, oh yeah, by the way, we have sovereign immunity. And the Court of Appeals goes, yeah, you're right, you do. And it's not waived. The actions of people can't waive it, only the legislature can.
All right. Thank
Sorry, I apologize for not being clear on that.
you. No, it's fine.
But I
I just
am-
wanted to clarify for the record.
With you on that. So then the legislature acted and the will of the people in House Resolution 1023, and they passed that law waiving sovereign immunity for the limited purposes of declaratory judgment actions. And then they said, such a waiver of sovereign immunity under this paragraph shall apply to past, current, and prospective acts which occur on or after January 1, 2021, right? If you take the petitioner's reading and say, oh, sovereign immunity's been waived, you write that provision out of the statute, right? You write that provision out of the statute, because what they are complaining about is all conduct that happened during the November election. There's nothing that has happened or happened after January 1 that these petitioners are complaining about, such that there's a waiver. More importantly, this is where Mr. Samuel and I, or the VRE and I, are a little bit of a disagreement. The next paragraph, which basically says, by the way, this waiver, you get to sue the county now, right? And that's what the petitioner said. We think we've got the right party now. It's the county. It says actions filed pursuant to this paragraph should go against the county. That's correct. If you had a proper action that was brought for conduct that occurred on or after January 1, 2020, right? So all of the arguments that were preserved in our motions to dismiss, like we are not a proper party, sovereign immunity, all that stuff is in play because all this conduct happened in November.
Mhm.
So, Judge, I think honestly that's a really simple way of disposing of all the claims against what we got, right? You could just sovereign immunity, you're done, and it took effect on January 1st. You could, if the court said, well, we believe that there is a waiver of sovereign immunity. I think there is a waiver. I don't want to read that January 1 language. I want to read that out of the statute in essence, right? I think that, we still, for all the same reasons Mr. Samuel raised, this isn't a proper declaratory judgment action, right? Not against Fulton County, not against the board, not against the clerk. You just don't get it because these petitioners, either they know or they don't know what happened in November. But again, going forward, right? Are they operating in the dark? Is there something that the court has to resolve for them? There's nothing that can be resolved. So, the cases, I dare say, are legion that this is not an appropriate declaratory relief action. And then so you say, well, what is this an action for, right? And I know the court has some feelings about this. I think you've sort of expressed it in hearings that this isn't an elections contest. Your Honor, this is an elections contest. That's what they're doing, right? All of the things in their petition, their amended petition, the second amended petition.
I think I've expressed in the past that they have not contended it's an election.
Okay, that's fair, and I appreciate that. Well, I'd like to say I'm not actually a lawyer for a living, but sadly, this is what I do. And so, and you could look at all the stuff that I do and go, yeah, he mostly looks like a lawyer. And that's exactly what this is, Your Honor. If you go through, you look at any of the complaint, the paragraphs in any of their petitions, right? Let me sort of slow down. OCGA 21 to 552, which is the grounds for the contest of an election, that provides, you can challenge an election for misconduct, fraud, irregularity by any primary or election official when the defendant is ineligible for nomination. That doesn't apply here. When illegal votes have been received or legal votes rejected, that's an issue here. For any error in counting the votes or declaring the result of a primary election, that's an issue here, right? Paragraph 20 of their petition, there was an abnormal 20,000 vote increase. Paragraph 23, 3 boxes of 100% Biden ballots were found. You know, paragraph 25, they observed what they believe are fraudulent and fabricated absentee ballots. Like, all these things are just traditional standard election contest complaints. The problem for them is they haven't complied with the election contest rules, right? And so what they've said is, well, this isn't an election contest. They know what they did or didn't do. They said, this is an election contest. What we really have here is an equal protection claim and a due process claim. And so it is what it is. That's the nature of their complaint. I think this is an election contest, and the court should find that they did not follow the rules pursuant to that, and you could dismiss it on those grounds. But that being said, even if they brought those claims, as a matter of law, we said in our filings, we don't run elections, but really it is, Fulton County is not the proper party. And what I'd like to do, Your Honor, is I'm going to move to admit, if I can, a certified copy of, it is the Fulton County Code of Ordinances, it's chapter 14, if I may approach.
Any objection?
I have copies for,
Pardon me?
I oppose it. They just made an argument that it's a 12B6 and goes to the 4 corners of the document.
if I may, Your Honor, actually,
I join in Mr. Harding's objection.
Your Honor, I can respond to that.
All right.
Excuse me. Sorry, a little tight over here. Your Honor, if I may bring the court a copy of the certified
Not
copy?
yet.
You want to wait? Okay.
You're gonna mark it?
Williams versus DeKalb County, which is an ordinance attached to the pleadings, does not turn a motion to dismiss into a summary judgment motion. Essentially, a certified copy of the local ordinance is self-authenticating. The court can take judicial notice of it. And if it is incorporated into the pleadings, which is what I would ask the court to do, you don't have to turn a motion to dismiss into a summary judgment motion. And so our first response was, let me say this, Your Honor,
Please continue. I'm just thinking.
yeah, that's fine. Again, the Williams versus DeKalb County case, that was the trial court, the court held, the trial court was authorized to consider ordinances attached as exhibits to pleadings on a motion for judgment on the pleadings, and in doing so, did not convert the motion to dismiss into a motion for summary judgment. And then they went on to say, within the framework of the complaint, certified copy of an ordinance could be introduced to prove the ordinance. But, so that's what I'm asking. I mean, really, Your Honor, you could convert it to a summary judgment motion, but you don't have to. There's no need to do that, because this is a matter of, local ordinance are acts of the General Assembly that apply uniquely to Fulton County. That's what this is. Self-authenticating.
All right. Any closing on the objections?
Yes, sir. Well, first of all, this isn't a judgment on the pleadings. This is a motion to dismiss. Relying on things outside of the pleading converts it to a summary judgment. We talked about that earlier. In addition, him tendering it today isn't a part of any pleading. It's just him adding it as evidence into the record. They haven't filed an answer, they haven't attached it to a pleading, so I think it's inappropriate.
Mr. Chile.
I would agree with Mr. Harding.
I'm sustaining the objection.
We'll just attach it to our answer at that time, Your Honor.
All right.
But regardless, Your Honor, whether you consider that or not, the argument is still the same. If you look at OCGA 21-240, well, I take that back. That's I apologize, Your Honor. That's I'm still sort of trying to read from the ordinance which you would not accept.
Take your time.
That's okay. Well, so the improper party, if Your Honor considers that, give me half a moment, Your Honor, sorry. So the issue is, as the court is aware, within the election code, there is the creation of a board of registration elections, and that is the superintendent of elections, right, for all counties. The superintendent of elections is named as the defendant in election contests, right? They call it the defendant. Not Fulton County, and certainly not after January 1st, right? But even if the court said, well, the statute says you can sue Fulton County only, there's a real issue in this case, and I don't think the court has to resolve that issue today to dismiss the petitioner's claims, but the real issue is whether the BRE, the Fulton County Board of Registration Elections, is a state entity or a county entity. We cite in our brief a couple of cases. The Casey case, which is cited in our brief, is helpful in that regard. It's Judge Story, the 11th Circuit. I lost my place. Judge Story in the 11th Circuit. He basically says, look, if this was just about who runs elections, clearly the BRE, the local BRE, is entitled to 11th Amendment immunity. I don't know how much you know about 11th Amendment immunity, but it is the proposition that the state cannot be hauled into federal court against its will, right? The state gets to say, oh no, you can't bring us into federal court. We're a state entity, right? We have a state or the state agency. We have immunity from suit in federal court. And so the court often goes through an analysis to determine whether a particular entity is a state entity or a county entity. The county doesn't get to take advantage of that 11th Amendment immunity. So the Casey case, Judge Story said, if we're talking about running elections, the BRE is a state entity. There is another case. It's the Georgia State Conference of the NAACP versus the DeKalb County Board of Registration Elections. Neither of these are binding precedent on this court, but they're both illustrative. In that case, it actually went back and looked at Casey and said, well, Judge Story said that in dicta. We don't really find that necessarily compelling. And for the purposes of registering electors, the court there said DeKalb County is actually a county entity, okay? So then where do we stand? Well, interestingly, there has been a lot of discussion in the media lately in lawsuits about SB 202, which is something the legislature passed, changed a lot of the ways elections are run, right? This was the thing, you can't provide water to people, right? You can't give out food. One of the other things it did was it said, we're going to act as a superintendent under certain circumstances. We can take over a local board of registration elections and do their job for them. The state can do that. That's part of that statute.
What does that have to do with this?
That would change the analysis in the case I just cited to you, the NAACP case versus DeKalb County. And I think that case today, had it been decided, they would come down and say, the BRE is in fact, a local BRE is in fact an entity of the state. I don't know how much federal law the court engages in, but that's like Manders versus the state rec versus Clayton County. Those are the factors that the court looks to determine whether an entity is a state or a county entity. And it's sort of like who pays for judgments, who provides, who basically pays for the entity itself, who has control over the entity, and then who sort of defines the duties and responsibilities. I think if the court went through that analysis, you might find that the BRE is in fact a state entity, and that's why you don't bring the county into court, right? That's why we're not a proper party. That all being said, I don't think the court has to get to that, because again, sovereign immunity, if they're bringing it against the county, we have sovereign immunity because these actions all happen before January 1st. Okay. So it's a long way of getting to the, if you found a waiver of sovereign immunity, you still don't get to sue Fulton County.
Thank you.
No problem, Your Honor. And I do have one last point, I believe. Yeah, and that is essentially the standing argument. The standing argument, it's well briefed in our briefs, and it is that they don't have a particularized form. It's really that simple. Even if you looked at the filing, I want to say it was Friday, it could have been Saturday. The things they're complaining about, oh, there's a happy faces contract. People are, they aren't good or whatever. And there's, what else did they say? I mean, they said a lot of things that frankly, the point is anyone can bring those claims. We don't need these 2. We don't need these 7. It could be anyone out here who voted in Fulton County. It could be anybody who voted in Fulton County. they're all in the nature of the same generalized grievances about the election. And if you have a generalized grievance, that's great or unfortunate, but you don't get to have standing for that generalized grievance. And that's the nature of all their claims. And so they don't have standing to bring. Thank you, Your Honor. That's all that I have.
Oh, thank you, Mr. Rosenberg. Appreciate your argument. Ms. Burwell?
Good morning, Your Honor. I too am vaccinated, so I'll take off my mask. Your Honor, it's clear the court has been working with this case for quite some time now, and you've seen the complaint and the amendments to the complaint. And the one thing that is very clear is that there is absolutely no allegation factually against the Clerk of Superior Court, and there are no claims raised against the Clerk of Superior Court. And their complaint is, including all of its amendments, is over 200 paragraphs, and nowhere in any of those 200 paragraphs is the Clerk of Superior Court mentioned. And that's because the Clerk of Superior Court is not a proper party to this action. All of their allegations surround processing of ballots. And as the court knows from looking at the election code, the clerk doesn't have anything to do with the processing of ballots. The clerk only has one role, and that's to hold the ballots. And so because there is absolutely no claim against the clerk, she ought to be dismissed, because again, she's not a proper party. And I just wanted to talk a little bit about one of the issues raised by Mr. Rosenberg, which was the fact that this is an election contest. And the state of Georgia gets to and has promulgated rules and regulations with respect to elections. Who has to follow what rules? And if you want to complain about an election, there's a way to do that under the election code, and that is to file an election contest. And as you know, the Fulton County Superior Court determined that this was in fact an election contest, which is why the case was sent over to Henry County for this court to handle. And that's pursuant to OCGA 21-2-523D. Because absent this being an election contest, this court doesn't have jurisdiction over this matter. Because if it's not an election contest, then this court wouldn't be allowed to handle the matter. And it only handles the matter as a result of this order saying that it's an election contest. And so the court needs to look at the state election board rules and the rules promulgated by the General Assembly. And, one of those rules is that in an election contest, it has to be filed within a certain period of time. And as well, the state election board is required to be copied and provided notice of the case. And the cases are very clear that the reason for that is because the state has the rules and the state has an interest in making sure that all the rules are followed. And that's why the state election board is required to be copied so that they have the opportunity to intervene, because we're talking about the state's rules and regulations with respect to elections. And that's something that didn't happen here. And that's something that is fatal to these petitioners' claim, the failure to follow Georgia law with respect to following the election contest, the rules there, and providing notice to the state election board. But even beyond that, Your Honor, if the court looks at, again, the only role the clerk has is in handling, keeping, holding the ballots. That's not a sufficient reason to bring the clerk in as a party. And so, it would be akin to, a doctor's office having medical records. And if in, support of a particular products liability claim or personal injury claim, you needed those records, you wouldn't hail the doctor into court as a defendant in the case just because they were the holder of the records. Neither here can these petitioners hail the clerk into court just because she holds the records. And they have made an argument.
Does the fact that the records, in this case, the ballots have to be unsealed, change your analysis in any way?
It doesn't, Your Honor, because the court can unseal and the clerk is required by law to comply with the court's order. And so it's no different than getting, records from a doctor pursuant to a subpoena. The clerk is required by law to follow, not only in 15.650 et sec, which is the section of the code that deals with the responsibilities for the clerk of Superior Court, but also in the election code, the clerk is responsible to, and there are remedies if the clerk were unable or unwilling to follow a court order. So the clerk doesn't need to be a party in order to be subject to the court's orders.
And the warehouse where the ballots are kept, is that a warehouse that is under the control of the clerk's office?
Yes, it is under the control of there's a portion of it that is under the control of the clerk. There's a portion that is under the control of the BRE. There's a portion that's under the control of the sheriff.
So the fact that the ballots are located in a warehouse that is controlled by the clerk's office doesn't change the analysis?
No, it doesn't, because she's still subject to the court's order. Even if she's not a party, she is still subject to the court's order.
And the fact that if there is to be some work done in connection with an unsealing of the ballots, that would have to occur in the warehouse that's controlled by the clerk, where the ballots are that have been unsealed by the court, then that also doesn't change the analysis.
Correct, that doesn't change the analysis.
Thank you.
The clerk is required to comply with any orders promulgated by this court. The other issue that we raised in our motion has to do with their request for temporary and preliminary adjunctive relief. And as the court knows, obey the law types of orders are disfavored. And so the clerk is required by law to keep them under seal and to keep them safe. And so an injunction that says to her, obey the law, isn't necessary and isn't required, because she in fact has responsibilities under the election code as well as under the section of the code with respect to the clerk's duties. And so for that reason, there wouldn't be any reason for the clerk, again, to be a party to this action, because she is subject to the orders of the court. The last issue I wanted to address was the sovereign immunity issue, and Laffer v. Deal is directly on the point here. And when they added the clerk, when they substituted the clerk in, that doesn't change the fact that she's been substituted in. It doesn't change her status in the case. It doesn't change anything other than the fact that she's now in her official capacity, which is what they requested. They requested the clerk be added in her official capacity. And again, under Laffer v. Deal, she would be entitled to immunity. And so on that ground alone, she'll be dismissed from this action.
And it's Lathrop, not Lathrop, is that right? I don't know. Okay.
Yeah. So we'll stand on the other arguments raised in our brief, Your Honor, and on any arguments raised by the other defendants.
All right, thank you, ma'am. Okay, let's start on this side, and then we'll go over to that side.
Thank you, Your Honor. Again, Bob Shealy, on behalf of petitioners Caroline Jeffords and Robin Sotier. Your Honor, listening to the arguments made by Fulton County attorney and the county Board of Registration and Elections attorney, you would think that there is no such thing as equal protection or due process under the state or federal constitutions, because their arguments basically say that fidelity, you can't do anything about it, even though we have incredibly important and demonstrated facts that show that equal protection rights and due process rights of our petitioners were violated. in the counting or the non-counting of 150 batches of ballots by Fulton County's election workers. It is shocking to hear these arguments in a court of law in the United States of America, where those are the bedrock guarantees of citizens against the abusive power of government. And that's what's on display here today, is Fulton County and the Board of Registrations and Elections, in their arrogance, seek to sweep out this courthouse door onto the sidewalk the rights of our petitioners to know what happened in this last election with respect to their votes. Their votes have been either marginalized or entirely diminished because of the actions of Fulton County's poll workers under the direction of Elections Director Richard Barrett. I would point out to Your Honor that the reason that we have a controversy here today is because Richard Barron basically abdicated his leadership last year in the 2020 elections. The Secretary of State threatened to take over Fulton County and run the elections after the primary last year by appointing a 21-member task force to oversee the elections. They appointed a monitor in the person of Carter Jones, who was charged with the responsibility of watching daily everything Fulton did leading up to the November 3rd election and the counting of the ballots. He issued a 29-page report that didn't even become public until last week, when investigative reporter John Solomon of Just the News, the former editor of the Washington Post, got that report from the Secretary of State pursuant to an open records request. They have sat on the information in that report, that 29-page report, which indicts Fulton County Board of Elections and their Fulton County Board of Commissioners oversight of that election, by pointing out such things as he witnessed personally, Carter Jones witnessed the same thing that we saw on the State Farm video. These scanners, these 5 women scanning ballots and batches, were scanning the same sets of ballots multiple times. Same batches. A batch is 100 ballots. If that's not denial of equal protection, I don't know what is. When one person, one vote doesn't matter anymore in this country. And the respondents in this case don't really give a damn whether people's rights to one person and one vote matter anymore. Because they come in here in their arrogance and argue that people don't have a right of redress anymore to the courts for violations of equal protection and due process. What's more, the Board of Registration and Elections in February 16th of this year, in a 3-2 vote with 1 Democrat switching over to vote with the 2 Republicans, voted to fire Richard Barron. And to show the control that Fulton County does in fact have over the Board of Registration and Elections and all their employees, all of whom receive paychecks from Fulton County government, the Board of Elections' decision to fire Richard Barron was overruled by a split vote of the Board of Commissioners to keep the same person who allowed 150 batches not to even be turned in to the Secretary of State to certify the vote. according to our expert who testified in this court back on May the 21st, at least 150 of them, 150 batches, that's 15,000 votes, weren't even turned in to the Secretary of State's office as part of the hand recount. We also know from the testimony that was presented by David Sawyer, our forensic auditor, that at least 29 to 30 batches were double counted or more. In one case, they were scanned in 5 times. Exact same votes for all 3 candidates for president. That's a statistical impossibility for that to occur. Yet, we hear the incredulous arguments that you would probably expect to hear in Cuba in a court, being made in a court here in this country, that fiddly-dee, these petitioners don't have any rights to redress in this court system. All they have is words on a piece of paper. That piece of paper happens to be the Constitution of the United States, and also the Constitution of the state of Georgia. Those words do have meaning. They trump any arguments that are made by high-paid lawyers in this court to the contrary. I would point out that the voters of this state in November passed by a margin of 75% in favor an amendment to the Georgia Constitution to remedy the kind of arguments that we've heard here this morning. Make sure that people's rights under the Constitution do matter and are given effect in the courts. Article 1, Section 2 of the Georgia Constitution, paragraph 5, was amended as follows. Quote, Section B1, sovereign immunity is hereby waived for actions in the Superior Court seeking declaratory relief from acts of, it goes on to name the states and its agencies and officers and employees of the county and the municipalities. And it specifically says that officers or employees thereof of any county in the state, or officers or employees thereof, who, quote, outside the scope of lawful authority or in violation of the laws or the Constitution of this state or the Constitution of the United States, sovereign immunity is waived. We have proof in this record and in our responsive pleadings in opposition to their motions to dismiss that there was unlawful activity. There was unlawful acts at Fulton County on the night of the election.
When does this take effect?
This took effect, and this is the important language, and it's a misreading, I respectfully submit, by Mr. Rosenberg. It says, the last sentence of Section B1 says, such waiver of sovereign immunity under this paragraph shall apply to past, current, and prospective acts which occur on or after January 1, 2021. This is not to be narrowly interpreted the way he wants to interpret it, Mr. Rosenberg, on behalf of Fulton County. This talks about everything in the past.
Since the beginning of time.
Yes. Current, now, and prospective acts, which occur on or after January 1, 2021. If it was otherwise, they would have just said, this only applies to prospective acts which occur on or after January 1, 2021. That's the way would be worded if Mr. Rosenberg was to be held correct in his analysis.
Well, if you filed suit today about an act that occurred on January the 2nd, that would be a past act, correct?
That's correct.
And so
But
I guess
this
what I'm wondering is if that January the 1st, 2021 language doesn't limit the past acts that can be addressed.
This language allows for a sovereign immunity to be waived for past acts or current acts or prospective acts which occur on or after January 1, 2021. Key word there is prospective acts. These are three separate classifications of where sovereign immunity is waived. It's waived for the past, it's waived for the current acts of government, and it's waived for prospective acts which occur on or after January 1, 2021.
So the date relates only to the prospective acts,
Yes,
as you see it.
yes. Otherwise, it makes no sense to include past and current. They should have just said only applies to prospective acts after January 1, 2021. But the language, the legislature is trying to cure a problem. Remember from the case that Mr. Samuels handled, Lafleur versus Deal. They didn't like the outcome. They didn't like and I'm sure Mr. Samuels didn't like the decision of the Supreme Court.
today.
I'm trying to help him out here too with his
I
argument.
think that one's over.
But it's clear, the legislature was trying to remedy what they saw to be a problem. The legislature was trying to reel in government and give people right of access to the courts for declaratory judgment relief against government. And this is the language that was contained in House Resolution 1023.
How is this case a case where relief under the Declaratory Judgment Act is appropriate?
I'm sorry, I didn't hear you.
I'm sorry again. How is this case one where relief under the Declaratory Judgment Act is appropriate? Where is the relationship between the parties? Where is the uncertainty?
Well, for one, the uncertainty is everybody wants to know what happened with these non-reporting of 150 batches of ballots to the Secretary of State. Were there equal protection rights and due process rights violated or not?
But it says past focused, but future focused,
Right.
or in the present.
Well, the courts of the state have held that the Declaratory Judgment Act is to be liberally construed and requires the presence in a declaratory action of a party with an interest in the controversy which is adverse to that of the petitioner.
But doesn't every one of the annotations that you see that follow the text speak to future rights, uncertainty between the parties going forward?
Well, part of the issue that we have here going forward is the man that presided over this non-reporting of a sizable number of ballots to the Secretary of State in the hand recount, Mr. Barron, is still running the show. And we believe that as long as he's running the show, this same sort of conduct is likely to continue into the future. And the Board of Commissioners has refused to fire him, even though the Board of Registration and Elections Board felt like he needed to go. But he's still there. And he's still gonna be running the show when the next election rolls around later this year or next year. And so part of the relief that we intend to seek in this court, Your Honor, after the audit is completed, and I've got an amended complaint ready to file today to this effect, but we're gonna ask this court to call the Board of Commissioners Rob Pitts, chairman, into this courtroom and ask him to explain why, given the outcome of this audit, where all these irregularities have occurred, which indisputably anybody's gonna have to agree if 150 batches don't even get reported and 30 batches are counted duplicate times, that's a violation of equal protection and due process rights. We're gonna ask this court, I'm gonna put him on the stand and ask him, what are you gonna do about it? You gonna fire Richard Barron? You're gonna keep him? I would ask this court, just as Judge Marvin Shue did in the jail litigation that went on for years, to make Fulton County clean house of every person that was involved in manipulating the results of this election the way they did. And also, I would ask this court, excuse me, to preside over the next election next year to make sure that whoever they bring in runs this thing properly, and not like it's been done in a third world banana republic this past time.
Well, let me just touch on the what you're calling a forensic audit. Obviously, I've granted the motion to unseal in the case. I have a more specific question related to what's already occurred. We talk about the count and the recount and the risk limiting audit and the like. Is there anyone to date that has examined the absentee ballots to determine whether or not toner was used on any of those ballots? In other words, has anyone looked to determine whether or not there was machine generation of ballots by use of toner as opposed to by use of hand? Has anyone done that?
I'm not aware of any evidence that that's been done from any source. And we do have.
You're looking at the focus of your claim is the introduction of, is a contention that there has been an introduction of counterfeit ballots into the mix, into the tabulation, correct?
Correct.
And you're saying that the absence of creases, the change in the differences in paper stock, and also the use of toner on some or all of those ballots suggest the existence of counterfeit ballots that have been made a part of the tabulation. Is that wrong?
That is not wrong, Your Honor. We have made the decision since the May 21st hearing when Your Honor announced that you were going to unseal these absentee ballots. We've retained a gentleman who's going to analyze those. He's a forensic certified document examiner, and he's got 9 other forensic certified document examiners. 10 people will be using high-powered microscopes to look at each ballot, each oval, and they can tell whether or not it was filled out with a pen or with ink from a toner from a printer. So whether it was filled out by a person or a printer.
And I believe that what your expert said is that this is something that we can learn, we can determine.
Sure, exactly. Sure.
That's not all over my hand, right? That's it. Yeah, that's right.
Hey guys, it's Dean here. So just looks like we are taking a break right now. It looks like they're getting set up for some live testimony. I'm going to continue to monitor this. I'm going to go back to the other video, let you guys just watch what's going on there. Let me mute that while I talk over it. It looks like they're setting up for the court reporters, getting her stuff set up. So it looks like they're going to do some live testimony. I'm going to go back to the other video and just kind of watch what's going on there while they're in the break, and then afterwards we'll come back here and do some commentary after the hearing is over, kind of see what the final ruling from this judge is.
Remain seated, come to order.
Please be seated. Thank you. Okay. Well set. All right, we're back, and apparently the technical issue that we had with WebEx has been resolved. And Mr. Cheeley, is there anything else you'd like to add to your argument?
Yes, just a couple of points, Your Honor. It's, Fulton County, Mr. Rosenberg made the argument that, this is an election contest. It's not. We've had 4 or 5 hearings, I think, thus far, and every time they get a chance, they say this is an election contest. And we keep saying, no, it's not. We've not alleged that in the complaint. We're not asking to change any outcome of the November election. We're just trying to get to the truth and to determine whether or not our petitioners' constitutional rights of equal protection and due process have been violated. And we want there to be a forensic investigation of these ballots, where there has been none thus far. And the people that we're representing have a right to know that. People of Georgia have a right to know that. We also would argue and point out to the court that our clients do have standing. They're registered voters, they're citizens of this state. And for Mr. Rosenberg to say they don't have standing is just misplaced. We, with respect to the clerk of court's argument, we named the clerk of court originally because Fulton County claimed they didn't have custody or control of the absentee ballots and envelopes. And that's why we felt like we had to get them properly before the court in order to secure those absentee ballots and envelopes. And we now know where they are. We know that they were not well protected over the Memorial Day weekend. The door was left unlocked. I don't know if that was the clerk's responsibility to make sure the door was locked.
Your Honor, I'm going to object. He's gone far beyond a motion to dismiss now, and he's getting into areas that aren't.
Let's save that. I believe there's another motion that is addressing these allegations.
But I was just pointing out that we wanted to make sure the evidence was secured. And that's the reason the clerk of court is in the case. We'll be happy to at Fulton County, and the clerk will put it in writing that those will continue to be secured, and perhaps we can let the clerk of court out voluntarily from this case. This moment here. This in closing, Your Honor, there is grave uncertainty about whether or not our petitioner's constitutional rights will be adequately protected in the future, because Fulton County has taken no steps to make a change. Rich Barron is still running the show. He's the one that was at the helm of the ship when it crashed upon the rocks back in November. And so there's every reason to believe that this sort of thing is going to go unabated by him unless we are given access to the ballots and the envelopes. That the ballots should have been mailed in to do an analysis, a forensic analysis, under the watchful eye of the special master, and to report back with our findings in trial before Your Honor to prove what the facts actually are with respect to the 147,000 absentee paper ballots, whether all of those are legitimate or not. So we believe that we're traveling under properly under the amendment to the Georgia Constitution, Article 1, Section 2, Paragraph 5, which clearly says sovereign immunity is waived because of the unlawful authority and unlawful actions of Fulton County's election workers. And we ask that the court deny the motion of Fulton County to dismiss and allow us to proceed with the audit.
Okay, thank you, Mr. Chile, Mr. Bundren, and Mr. Harding.
How are you, sir?
Fine, thank you.
Well, I'll be brief. I think you covered a lot of what I've covered, but first, I think service has been taken care of. Everybody acknowledges that. The 12B6 issue, Your Honor, I mean, Walker County v. Tri-State Crematorium, dismissal is appropriate only where a complaint shows with certainty that the plaintiff would not be entitled to relief under any state of facts that could be proven in support of his claim. As far as the debt judgment statute, 942, paragraph B, it does say whether or not further relief is or could be prayed in any civil case in which it appears to the court that the ends of justice require that the declaration should be made. We're not asking the court to declare that we have equal protection and due process rights. We know we have. We're here to have it declared they were violated. If the court would look at the first petition and my second amendment to it, it says the court declares that the respondents have violated state equal protection, that the court declares that the respondents have violated state due process. Nowhere in here do we ask the court to declare anything in relation to the November election. The November election is just simply the most available and current evidence to show how elections are conducted in Fulton County. So we're asking for it under discovery. We're not asking the court to declare anything with regard to the actual result of the election. That's the next thing. We keep talking about an election contest. Under 21.2, I believe it's 520, paragraph 1, states, a contestant in a statutory election contest, or some other language, to contest the result of any primary or election. We're not asking you to do anything about any particular result. We're not asking you to take any action in regard to even the eligibility of any candidate. What we're saying is we think counterfeit ballots were counted in the November election. And that those ballots basically amount to ballot stuffing because they dilute the weight and value of my client's vote. And there's this argument that, oh, it's not a generalized argument that anybody in this state can bring, because not everybody's vote was actually lessened. Some people's vote was strengthened. You have counterfeit ballots being put in, or you have ballot stuffing. Whoever wins, you strengthen the value of those people who voted for that candidate, and have lessened the value of those who voted for that candidate's opposition. So it's not just generalized anybody, any Tom, Dick, or Harry from anywhere in the state can bring this action. No. It's not generalized. Also, in regard to the future acts, that's the problem here, Your Honor. The November election, we think, is indicative of how these elections are conducted, and that's the evidence that we think shows that my client's future weight and value of their votes may be affected in future elections.
This is the bottom of page 2 and the top of page 3, if you agree, correct?
Yes, sir. Well, we looked at where it's at. Yes. From the bottom of page 1 through page 2. And then the election contest part of page 4, where I brought that up. And some of the language they use is, you gotta be uncertain to your right. The November election is not the only federal election that's going to be conducted in our great state. It's getting ready. There's going to be a midterm here shortly, then there's going to be another presidential election. There's going to be other elections that are going to be conducted on a local and probably even county level. So this uncertainty is, what's the value of my vote going to be in the next election? In particular, if there's 50,000 or, 5,000, whatever number, counterfeit ballots pumped into the election, into the ballot box. Anticipated action to take. The action they're gonna take is vote in other elections, Your Honor, in the future. Ongoing or imminent dispute, well, again, elections are ongoing, they're gonna be voting. Uncertain future action, they're gonna be voting. They want that vote to count. Somebody used the term one man, one vote, one person, one vote. Well, if there's dilution, then it's not one, it's less than one. It may give a prevailing party more than one, as far as value goes. In addition to sovereign immunity, future elections are going to happen after January 1st of this year. So I think to the extent of the way this complaint and its amendments or petition and complaints amendments read, what we're saying is there are going to be future elections after the 1st of January of this year, so they waive sovereign immunity to the extent of declaratory and injunctive relief. Of course, I believe the sovereign immunity amendment requires you to grant declaratory relief first before you can go to injunctive relief. But in our amendment, we pled account for injunctive relief. We're not asking the court to say we have equal protection due process rights. We know that. We're asking the court to say they've been violated or will likely be violated based upon the conduct of the November election. With sovereign immunity, I don't disagree a lot with Mr. Shealy, or even the clerk's attorney for that matter. I think the only way you could probably bring the clerk in would be as an individual, and I don't think we have any claims under a Lafferberg v. deal that we could assert against the clerk. We'd have to say there's some type of unconstitutional act or challenge the constitutionality of the statute. We're not doing those things in relation to the clerk. However, the board, the county board, I think the amendment clearly says they're a party, Your Honor. Past, present, we are not asking the court to declare anything about the November election as far as the results go. We just want to determine if there's a number of counterfeit ballots in there, and then will it likely affect future elections? Will that activity continue in the future? We think it will, if it's been allowed. To say you don't have a right to bring that action, Reynolds v. Sims, which I cited, they specifically mentioned nor diluted by ballot counting, ex parte Cyble, it's a U.S. Supreme Court case. So, the notion that you can assert that your equal protection due process rights are violated, to me, it seems like a stretch. And the Declaratory Judgment Act, says, hey, just asking for a declaratory judgment is sufficient. You don't have to ask for anything. We're asking to look at the ballots as part of discovery to show that there was a dilution. And then again, ask the court to declare that it will continue. You've never asked for any specific relief in any complaint that I can recall that wants you to do anything with a result or a candidate. Lack of standing. Court's aware there's basically three parts to standing. Injury in fact. Well, violating someone's constitutional rights is an injury in fact. It's not, again, not generalized. It goes straight to these individual people or to the people who voted for the losing candidate, really. Because they're the weight of their votes are the ones that are being adversely affected. Of course, if you're on their side, they're positively affected. A causal connection between the injury and the conduct. Well, the conduct is allowing counterfeit ballots into the mix, to use your word. The county's the one that does that. Now, whether it's the board, the election board, the county, I really don't care. Somebody is responsible, Your Honor. And I think that's where 9/11/21 comes in. If the court feels that the claim is viable and not subject to 12b-6, the question then becomes who should be sitting over here? And I think the court can address that independently under 9/11/21 As a misjoinder. I don't necessarily think it's a substitution because there isn't a transfer of interest. I think 9/11/24 would require some kind of transfer of interest. When we brought the original motion to substitute, it's because we argued the sovereign immunity amendment had transferred that interest to the county board versus the individuals who were originally named. But the misjoinder, the court in sua sponte actually addressed that, is my understanding. And basically add or drop parties. So the court felt the election board needed to go, you could drop them and add the individuals in place if you thought they were the proper party. The county, same thing, drop them, you could add the county board members as parties. Clerk, drop the clerk, add her as an individual, but again, I don't think that's proper, it's just an example. I think under 9/11/21, you have broad discretion and authority to adjust the parties by adding and dropping, even on your own motion, that's the way I read it. So what I was asking is, we had a new constitutional amendment, I think a lot of it is kind of up in the air, I don't even know if there's any case law, I haven't seen any, but we think the county is definitely a party under the sovereign immunity amendment. We'd ask the court, if the court decides the board needs to be dismissed and that somebody who conducted the elections needs to be parties, that they put the individuals back in. And why? Well, because they're the ones who are responsible for conducting the election. So if there was an equal protection or due process violation, that's an unconstitutional act, and they can be named as individuals under that provision. My understanding of that case. Don might have a different angle on that.
Then it becomes a question of what, of official immunity.
Yes, sir. Which we take care of at a later time. But this whole premise of this election contest, there's not been one requested relief for anything to do with the actual election result or action against any candidate. I think the standing, injury and facts, the constitutional issues, the county conducts the elections, redressability. The Declaratory Judgment Act says just the declaratory judgment is a sufficient remedy. So that's redressability. That act says that the deck judgment itself is sufficient. So that would be the redressability. We don't have to have a declaration and order them to do anything. That's not what the deck judgment act says. It just says that you can declare rights, you can clear up uncertainty just with the deck judgment, just with the order itself or the judgment itself. Yes, well, I think I talked earlier. But just the future acts again. There are future elections. I've alleged that in my Second Amendment. So it's conduct that could likely continue, and we don't think you have to actually challenge the result of the election to address that issue, which is what they argue. Oh, you wasted your remedy. Well, we're not attacking the result of the candidate. We're wanting the constitutional issues addressed. An election contest wouldn't resolve the constitutional issues. It would just order new election. That's the remedy under the state election contest. I think it's 527 or 528. But we're not asking you to order a new election. We're not asking you to do anything with a result or candidate. We're saying that we think there were ballots that were counterfeit, counted in November. That activity is likely to continue in the future, and we're uncertain as to the weight and value of our vote, my client's votes, going forward. And that's what we're trying to address. We're not trying to address the result of the November election. We've heard a lot of that. It's just not true. That hadn't been pled. We've asked to see the ballots because we think that's the best evidence to show that this type of conduct has occurred, and then it may occur in the future. our request for the ballots was actually a discovery request. It wasn't a request, I believe, under the Declaratory Judgment Act. We just asked that you order us to look at that, and we served a third-party notice to produce on the clerk, which is what we were operating on up until the time they were added as a party. She was added as a party. So I think based upon those things, Your Honor, I think the complaint and its amendments is sufficient to survive a 12B6. And I think we've shown that they're standing. And I think the sovereign immunity, who it applies to, I don't think it applies to the election board because these are acts after January 1st that we're actually asking the court to adjudicate. The registration board, I keep going back and forth on it, to be honest with you, reading the Lathrop and reading the sovereign immunity amendment. That's why you pay the big bucks, Judge. We'd ask you to deny those motions and adjust the parties under 9/11/21 to the proper parties. Thank you.
All right, thank you. Okay, well, Mr. Chile, I'm going to go ahead and turn it now over to this table and see if we have responses, or I should say, a closing on your motion to dismiss.
And Your Honor, may I be allowed to respond on behalf of the BRE, even though I didn't do our?
Yes.
Okay, thank you. I have 3 points to make. The first, I just want to address a question, and I'm also fully vaccinated. I want to address a question that the court put to Mr. Cheeley, which was whether anyone had looked at the ballots, the absentee ballots, to see if they were machine generated. And I just, because we're on the record and in the forum, I wanted to respond to that and let the court know that in fact, the Secretary of State's office has investigated that, is investigating that. There is an open investigation into all of the complaints regarding Fulton County and specifically what happened at the State Farm Arena during the tabulation. The Secretary of State's office and their investigator also pulled the specific batches that were identified by the petitioner and their witnesses. They did not, my understanding is they did not find what the witnesses were alleging. That report's not public yet, but the investigation is ongoing. And I do believe that Mr. Callaway was deposed in this action, and his deposition transcript has been filed and made part of the record in this case.
And who is Mr. Callaway?
He is the Deputy Chief Investigator for the Secretary of State's office. So I just didn't want to let that go without responding to that. So as to our motion to dismiss, I really did not hear anyone address why we are wrong about sovereign immunity as to the BRE. So I'm not going to spend any more time talking about that. I think the constitutional amendment was clear as to the BRE. I do want to respond to Mr. Cheeley and Mr. Hardy's argument with regard to declaratory relief. Everything I heard both attorneys say in terms when the court was pressing them, yes, but what do you want the court to say about the future? There wasn't a response. They kept saying they wanted the court to declare that their client's rights had been violated in the past. And that's not the appropriate subject of a declaratory judgment relief. I heard Mr. Cheeley say, we just want to get to the truth. We just want the court to say that their rights have been violated, and we want a forensic investigation into these ballots. It's worth pointing out that they are getting the inspection of the ballots. That's not what we're contesting. The court has already said that's going forward under the guidelines or under the statutes that are set forth, and we're going to have a meeting, I assume at some point, to still deal with the protocol issues and the open records requests. But that doesn't deal with the court's question about the appropriateness of declaratory judgment relief. I looked at, and I went back to double check for myself. I went back and looked at the complaints for the petitioners. When you come down to the prayer for relief, nowhere does it say anything that they want to declare, that they want the court to declare about something that should happen in the future, about their relationship to the BRE, or about some right that they are unsure whether or not they have. what they say is they want the court to declare that certain things that have happened already violated their rights. And I guess if you read the complaint, that's the end of it. They're not addressing anything about a controversy that exists now. And we heard a lot about Mr. Barron and bringing him and Chairman Pitts into court. Nowhere is that in the complaint as relief that they are asking for.
If the government entities are able to avail themselves of sovereign immunity and are not parties to the case, and if the individual parties that they're seeking to add to the case are not subject to declaratory relief, then at what point and how do you get to the work that they're asking to be done?
Under the Open Records Act. And that's what the court has already ruled on and adjudicated and has said to them, you have certain things that you are allowed to do under the Open Records Act. They've asked the court to unseal the ballot images, which the court has done. That's their vehicle for and that's what I heard Mr. Cheely really saying, not his exact words, but the import of his words. They want to go look at what the court's going to give them access to. And then they think they will be able to come back to the court and say, look, now we can show you that there's been fraud or counterfeit ballots. But they're going to have to plead that in a complaint. They haven't done it so far. And I just want to also touch on, I think something that Mr. Harding just said at the end there, that when he was addressing, well, what is the uncertainty? And he was saying, my clients are uncertain about whether their vote is going to count in the future. If you look at his second amended complaint, what he asked the court to do is to grant a permanent injunction to enjoin and prohibit the respondents from counting counterfeit ballots in future elections. We agree with that. We will not count counterfeit ballots in future elections. Even if we were to assume for the sake of argument that they were right, that they were counted in the past and we're not admitting that, we agree you can't count counterfeit ballots. You can't scan absentee ballots twice and count somebody's vote twice. So that's why we say there is no current controversy. There is nothing for this court to declare and resolve about our future conduct or our relation with these petitioners.
Okay, thank you. And let me see.
Yes,
Mr.
sir.
Rosenberg.
I will also attempt to be brief. Just with respect to sort of the discussion about sovereign immunity and the date of when the House resolution became effective, amended sovereign immunity. If you read it the way Mr. Cheely suggests, you're eliminating essentially the past and current, like the words, I don't know if you have it in front of you, but the words past and current have to modify something. And they modify acts, right? And acts are those things which occur on or after January 1. You just have to read it that way. Otherwise, you're eliminating a portion of the statute. You shouldn't read an amendment, a constitutional amendment or a statute to eliminate a portion of that. With respect to, I just want to address sort of the county defendants are being flippant and they don't care about our rights. I don't know if the county has commented on sort of the passengers in the car, right? The claims that they're making, which are significant and substantial. What we're commenting on is the vehicle that they're driving, right? The declaratory judgment approach. Where they're driving the vehicle, right? Trying to attack the county for that, even though we're immune. There are provisions, the legislature has provided a remedy if you have concerns with the way an election has been run. It's been challenged in the state, the same very election, in Fulton County Superior Court, the United States District Court, Trump versus Raffensperger. It's 2020 CV 34. You can barely read it, 343255, right? These claims about the 20,000 ballots, they have been litigated. There's also Boland versus Raffensperger. Interestingly, the Secretary of State is the defendant in all these cases. 2020 CV 343018. So these claims have been raised properly before and disposed of one way or another. There's a Linwood case versus Raffensperger. That's in the United States District Court. I think we referenced that perhaps in one of our briefs. But I guess that's my point is we're not really taking issue with the claim so much as you just can't get that relief here from us currently. Lastly, Judge, you inquired, well, what can a court do or what can I do? I would implore the court to sort of look at the election code as I know it has, take a relook at it. This court is empowered to do a lot of the things that the petitioners have asked it to do. If they do it in a timely fashion and serve the Secretary of State or the election supervisor for the state, and they take the appropriate steps after an election. It's all in 21-2-520 at sec, really 21-2-525. Talks about the court having a hearing and having an opportunity to do all these things, but they haven't followed that path.
Is it your opinion that the Open Records Act authorizes the unsealing and inspection of the ballots for the purposes the petitioners are seeking to do so?
Sure. The change to the Open Records Act, right, it allows for ballot images. Ballot images are separate and distinct from the actual physical ballots, right? Those ballots are under seal. They're under seal pursuant to statute. Now, the courts unseal them. So I guess my simple answer to your question is, does the Open Records Act provide an ability for this court to unseal those physical ballots and have the petitioners look at them? I don't think that it does. I think the remedies are pretty clear in the Open Records Act itself for violations, and they don't account for anything like that. I mean, it's always been the case. You don't get the records if someone violates the Open Records Act.
If the 300 DPI images are insufficient to address the concerns of the person who has the Open Records Act request, then does allowing them access to the original for a visual inspection, does that seem reasonable or unreasonable to you?
That's a good question. Judge, there's a couple things that I would say about that, right? The Open Records Act doesn't require you to create a record that doesn't exist, right? So if the records
does exist.
No, but if the image, so that the images exist as 300 DPI images, we're not required to generate a greater image, right, with greater dots per inch. Secondly, the Act does talk about allowing physical inspection, right? And I think that's appropriate in most circumstances. But these records, again, are under seal, and I know the court has said you can unseal them.
I have.
Yeah, I know you have. And I don't know, I mean, I take issue with it, but you've done it. So let them look at them. I mean, if that's what the court's position is with respect to that. But I just don't know that the Open Records Act requires all that to happen because they're under seal. And so they're therefore exempt from public disclosure under the Open Records Act.
Okay.
And I apologize for beating a dead horse. I just don't think the Open Records Act provides you guidance with respect to how you do all that.
All right. Thank you. Ms. Burwell.
Well, it appears to me that everyone agrees that the clerk should be in, so I don't have anything else to say.
All right. Well, it shows that you've done your job today and done it well. Let me see. I believe that's everything. And that's all that we, I know, Mr. Chile, you want to say something else. And I just want you to know that if you do, I'm going to give everybody else an opportunity to respond to it. And I want you to be mindful of the time that we've devoted to this. But then again, though, it's a, I think what I'm going to do is just go ahead and let you have your say.
Thank you, Your Honor. Let's be real brief. I did want to note for the record that we did present proof to the court in our supplemental brief in opposition to Fulton County's motion to dismiss. We did file yesterday a supplement that attaches an Exhibit A, which is a contract between Fulton County, Georgia, a political subdivision of the state of Georgia, and as the county and owner, and then Happy Faces Personnel Group, which is the contractor. And this contract is for, as you'll see in the detail, it is for a whole host of services related to elections. So for Fulton County to say that they don't have any control over elections when they're the one signing the contract for all the staffing services provided by Happy Faces is just not accurate. And we also attach, and we will file the original of the deposition of Mr. Ralph Jones. He is Director of Registrations for Fulton County. I proposed him about a month ago on May 17th, and he said that he was employed by Fulton County. So there is no distinction. This is a argument is a distinction without a difference. So that's all I have.
Any response to this, Mr.
No, sir.
All right, Mr. Harding? No,
No, sir.
nothing from any of the respondents. All right. Okay. Well, that's where we are on the motion to dismiss. I'm going to take the motion to dismiss arguments under advisement. We've had a number of last-minute filings. We had some spirited argument, some changing of position, and I think it's important that I take a little bit of time just to review it and think about it. So that's what we're going to do, take that under advisement. The next piece that we have to look at here, I suppose, is a motion to close the hearing that's been filed by the clerk.
Yeah, Your Honor, we will withdraw that. We weren't sure if something was going to come up today with respect to issues that occurred, but the sheriff has yet to finish his investigation. And so now that Mr. Shealy has filed a motion, we'll be responding to his motion, and we'll provide support for our response then.
All right, thank you. Is there anything else that we have to do today?
Your Honor, just one last thing. The defendants have now been served, and so we'll have answers due. So I was wondering if we could wait until the court rules and maybe give us 7 days until after the court rules to file answers, unless you want us to go ahead and.
7 days from the time that the court rules?
Yes, sir.
With sufficient time to answer?
Yes, sir.
Is that true for all of you?
Yes, Your Honor.
True for the county, though, for sure.
Okay, to the extent that you're still in the case, and of course,
No objection.
no objection?
No objection.
Okay, we'll adopt that schedule.
Thank you.
Thank you. And yes, ma'am.
I didn't mean to interrupt the court. I had something else I wanted to ask. Just to be clear, we are, we had filed that motion for a protective order, which became moot because we agreed not to go,
No depositions until I've read,
or other discovery.
or other discussion.
Thank you.
And I'll try to get an order out just as quickly as I can, but I feel the need to ruminate a little bit to really deeply understand a couple of the points that have been made today. Thank you. And if that's all, then is there anything else, Mr. Chili?
Yes, I would just ask for the court's enlightenment on what we should do with respect to the motion that I filed to change the venue where the audit would occur.
Well, that was just filed.
Right.
Isn't that right?
Right, that's
And,
just
and
part of it.
doesn't it depend a little bit upon who's in the case? And I don't know that we want to get overly involved in that aspect of this right now. This goes to what the clerk's talking about. I've already managed this issue for the most part on the phone. Immediately after the Memorial Day weekend, We got assurances from the sheriff's department that they understood that they are responsible for making sure that the warehouse is secure, and they fully understand that. I'm not so sure that there's much more that we can do than that. We can't turn it over to somebody else's control. They are the ones required to maintain the security and safety of the warehouse and the ballots therein, along with the clerk who has that duty. And so I'm going to hold on that piece unless you're insisting on having that motion heard right now.
I'm not that concerned with the level of security that is now being provided by the sheriff's department, but I just wanted to put this on court and the party's radar so that we all agree, and my experts are telling me that the space, the relatively tight space at the Fulton County warehouse is not sufficient in size for them to adequately do this audit and examination of ballots. So we just have
I read that, and I saw that you're proposing the Georgia World Congress Center instead. Is that correct?
Yes, sir, and that's where they did the hand recount of the absentee ballots in November. And we just need to let the World Congress Center know they've got a room sufficient size available now through the middle of August.
Starting on June the 28th.
Yes, sir.
I remember. It's just that the other issues are vitally important and need to be addressed before this one.
I understand. I just wanted to make you aware that we do feel like once the court gets to the point where you're ready to have an organizational meeting, then that's going to be one of the topics, I'm sure.
Should that happen, that's what we'll do.
All right.
Thank you.
Thank you.
And you're all excused. Thank you for being here. Thank you for your argument.
Thanks, Judge. I'll get it. Thank you.
Okay, so that's the end of the hearing here, and it looks like the judge has pushed this off, taken it under advisement, which just means that he's going to take some time to figure out how he wants to rule on this. Sounds like he's on the fence on some things. It's not clear cut at this point, so he's going to do some research and come back in, looks like, a few days, and at that point we'll know more. So I'm going to end the stream here. I'm going to come back probably later on this evening with a live stream on discussion about what happened today, what was argued today. I'm going to go back and watch the video and get some points out of that, and come back probably about between 6 and 8 o'clock p.m. Eastern with a live stream on the details of what was discussed in this hearing today.